And broadcast, I think we're live. Yeah, we're live. 4 seconds. I'm waiting on Patrick. The internet's just come back here in South Africa. What we're waiting on is our dear friend Jonathan to appear in court and talk about race day quads. Let's see if we can get the court link up. Here we go. Let's get that up. Let's see. So yeah, all a bit shabby. Patrick should be along shortly. All right.
Central question, the delegation language does not need to be unmistakably clear, and that's why that distinction is critical, and that's what makes pennies different. But moving back to the categories of cases, which are most of the cases that we see.
This is audio only.
Did New Jersey seek to set aside FERC's order in pennies?
No, Your Honor. Actually, it was a constitutional facial. Your Honor, as I see, my time has expired. I've been at all. Can I?
You can continue.
If anyone's watching, I'd really appreciate it if you can give me a heads up whether you can hear it or not. Let's see.
Thank you, Your Honor.
Here comes Patrick.
Well, so my follow-up.
I'm not so sure if the audio is coming out on this, Patrick. Can you hear it?
I hear it.
You can hear it via yours or via this?
Set aside FERC's
By this, I turn
No,
my.
Your Honor. Neither New Jersey nor we seek to modify the actual order, and
you don't want to set
let
aside
me
FERC's order?
quickly go
no,
to
Your Honor.
my browser
That's
and
not
see
the.
if it's...
That's not.
So this is the proceeding case, I
relief
guess.
that we seek. We seek.
Yeah, right before it's
to
so and so.
find, that the entire.
Excuse me while I see
Or
this.
should be up next.
Okay, it's working.
We
Okay,
want the
got
NGA
it.
to be found unconstitutional. That's what,
Why do you want?
Oh, what a
why do you want
panic.
it?
I thought this wasn't going to
under
happen
the non-delegation doctrine.
because
Why do
our
you,
internet went away for the
your
day,
client,
as
opposed
is
to
what it
the,
wants to do. I'm just turning that down. Is that turned down for you as well now, Patrick?
Yes, it is. Yeah, I should have. I signed up for Starlink and I got it and stuff, but then I canceled.
You got it?
Yeah, I didn't want to pay the $400 for the equipment. And if I would have sent it to you, it would have probably cost me $500 to send it down there.
But it wouldn't have worked because the cells wouldn't have been opened up. But yeah, it's all been pushed back to 2023 for us. I've paid my deposit. I'm waiting like a good boy. Paid the deposit on the first or second day after I opened up, but yeah, who knows. So let's turn this down again, right down, because we know that's not them. What are we expecting to see here shortly?
What we're expecting to see is, Jonathan Ruprecht has been spending a lot of time, working on this case, basically bringing up points. A lot of the I don't know if we'll get mentioned in the arguments, but in the brief, a lot of the stories that we've run, some of the FOIA requests that have made and were actually replied to are cited in this. What's really going on here is, I've been harping for I don't know how many years on the backroom deals, the ex parte, where you have people in there that are getting privileged information. We had that with the RID proceedings. You had people in there, again, some people think I'm a curmudgeon, but you have people in there that were trying to, let's say, peddle their own technologies, patented technologies. Hey, this is going to work. That's going to work. And the FAA was dealing with them. We had some of the FOIA requests. I tried to find out who was at the meetings and who was presiding. And for some reason, this woman, Jennifer Ambrose, just does not want to be associated with the proceedings. They redacted her name in FOIAs, which seems silly to me because if someone's a public employee working in the public charge, what do they need privacy for?
Yeah.
So
It's just,
I think there's some
Orders
inconsistencies
that
there.
were being that were involved
And
in
we're
sorry, I
those
also-
just
claims
want to
because
turn the
they
volume
were
up just to see
certificate
if
orders
it's
in both of those claims. And this
saying it's
court,
still the same one, isn't it? Yeah. Okay. So still
Yeah.
the first case going on, and they've got 10 minutes each, I think, haven't they? Something like
Yeah,
that.
it seems to be that they ran a little long. The last case ran a little long with rebuttals and whatnot. So I'm not sure how, when this will start. This is one of those, fly by the seat of your pants deal. But I think we'll also.
I didn't even think I was going to be here. But one of the funny things with the way the internet works here and now in the world of streaming is they tend to get it back on for 5 o'clock because I think people go nuts if they miss their streaming and stuff when they get home from work. So it used to be that it would have been off all night, but now they tend to get it back in time for summertime streaming. So that was lucky. I didn't think we were going to be here, so
Well, it all worked out.
it all worked out.
I think the other thing we're going to hear here is some Fourth Amendment stuff. There's warrants, and I think Jonathan will explain how this RID thing will be on all the time, and then it almost is a warrantless search. I think we'll talk about that, and then there'll be some First Amendment issues. I also believe there's some issues with minors giving out
Morning,
locations
Mr. Solomon.
of where people are. Going to be some issues. And then also...
Good morning, and may it please the court, Robert Solomon for the commission. Your honors, I think I will start with Judge Walker's question. What were the plaintiffs here seeking to do? What was their intent? Were they seeking to modify the FERC order and the FERC certificate? And the district court judge here...
The FERC order. Hooray for the FERC order.
Well, the FERC is that's a big deal here.
What the FERC is the FERC?
Well, FERC licenses all of the dams and water pipelines. So when the Oroville Dam up here it was ready to collapse, FERC is supposed to certify that every year or every other year, and in that case, they couldn't find the report. But anyway, that's what FERC does.
Somebody with a great deal of a sense of humor must have sat down and written that acronym, though. Why do we end up with RID and the dams get FERC? Why can't we have something like FERC? Come on.
Yeah, well,
Counts 2 and 3 challenge the subdelegation of eminent domain authority to private entities, including Mountain Valley Pipeline. The complaint sought to void.
Do you have the same problem as we have over here, that things get privatized and then they don't get fixed because the shareholders want their money every year?
Well, I've joked about this, that California is really trying to emulate the country that you live in. It's really kind of an interesting thing here. But, as we're seeing, I think that, in the case of certification and whatever else, it's not the machine's not working the way it's supposed to. Let's just leave it at that for now.
How long after the previous one?
I think the answer is yes, but I need to qualify. New Jersey was in fact a party in the FERC proceedings and did petition for review. The various instrumentalities of New Jersey are petitioners in the 18-1128 et al. Case, which is captioned as.
What I'll do when we think it starts, we'll quickly just say again what this is going to be, and then once it's over, I'll cut the video to what's happening.
Sure.
Articulated to the Court of Appeals on review.
And just if you are watching, if anyone can just confirm in the comments that you can hear the audio as well. I'm pretty sure you can hear
as the Supreme Court found in
but I'd really appreciate it if someone can,
that was a defense to the state of New Jersey being hailed into federal district court, and was a defense that allowed the
what it's official.
Sadly, I think I, as much as I want this to be successful and to open up lots of cans of worms, I think this is just going to get rammed through. Sadly, I don't mean anything against Race Day Quads, Tyler and Jonathan, but I think there's too many heavy hitters pro this whole remote ID thing.
I would concur, and I think it's just like the registration. They set these deals up, and then they get the usual suspects in there. Everybody thinks they're going to get something out of this deal that's in the room. They give consensus, okay, whatever you want. The FAA goes along with it. I know they were under pressure from Homeland Security to get something together. But I still don't see, how this is going to work. And I don't know how it is where you live, Gary, but here, the only people that follow the laws are like the law-abiding people. And if people are doing stuff that's
there is a part
legal, they don't follow the rules. And I don't see where this RID, people toggle it off or, whatever. Like ADSB, people put in the wrong altitudes and whatever else,
It's not going to work. It's
of state sovereign immunity, because as the Supreme Court found in Penn East, the certificate, the FERC order,
still FERCing. It's not going to work anywhere in the world. It's not going to be fit for purpose. The whole Wi-Fi idea. But what I don't think the community has realised is that the position of the operator. That's the bit they've been arguing about. One of the Freedom of Information requests. Or was it a FOIA, or did we? Oh no, somebody told us about it. That was it. Somebody told us about the Z accuracy not being fit for purpose. The Z accuracy not of the airframe, but of where the operator is with the controller. And you can't get the Z accuracy out of standard smartphones. And I think, correct me if I'm wrong here, the FAA quickly put out a slight amendment which wasn't put through in the correct order, and they were having a word with Google and Apple saying, hey, please up your game, we need you to do this. They tried to certify something away that would have been possible. You do better than me at unpacking that.
Well, that and I think there's already been some, that's I guess case law or some hearings and with the cell phone or
is it your view?
Kind of getting into trouble with some Fourth Amendment
to raise them in the certificate
and things like that. So I think you have multi levels of issues with this. The other thing is this was sold, and I talked about this yesterday a little bit on the Hangout, on how this is going to be open the door for beyond visual line of sight, right? But if you're giving the location to the operator is really what you're zeroing in on. How is this going to work with the aircraft? There's latency issues. There's they can't even keep Lance up. Lance has outages and stuff. I just don't see how any of this is going to work, and I don't think it's going to work. I think that even if these guys are successful, the FAA will throw them under the bus and go, oh, well, beyond visual line of sight was next year, and now it's all off the table, and
this is the
pariah over here, it's his fault, and because it was all going to work out, which is just not true.
Let's just see
a generic exception that if there is a delegation claim or if there is some type of constitutional claim that necessarily.
How long did they give them on the previous case for the chitter chatter after they've made the case?
Each side had 10 minutes, and then they were able to come back and rebut and whatnot. But they said they went a little long. But
in the certificate
we
order,
must be getting there now.
Said that it wouldn't act as.
Yeah, the remote ID was an idea of a particular UTM company that bought into a module manufacturer. In fact, looks at desk, has one of those modules on his desk somewhere. It's a LoRa module. Here it is in a feather. Bought into that company that makes those modules. long time before we started hearing about it as an idea. And I think everyone else has picked the ball up and has started running with it without really thinking. It's like they think it's a silver bullet, isn't it? It's like, oh yeah, that'll do it. It'll be all right. Everything, once you've done this, everything will be fine without any further thought on the thing.
The agency's public convenience and necessity.
Yeah, you have to give them credit that they're coming up with solutions
and even
that
more
they don't understand, and that's one of the issues that I have with the airspace integration effort. Is most of the people that are involved with this are, and this has been a constant. I'm not telling you anything you don't know. They have no idea about public policy or aviation or the nuances or how it works or the global community and all the rest of this stuff. And they're just, everything is like, we have a cell phone app for that. This cell phone app is going to do it.
Yeah, and, that is the bottom line, isn't it? It's all been a very Silicon Valley solution to a problem that didn't actually exist, didn't need to be addressed. And well, if you are going to do it, you better think a little bit harder. Here we have a chain of ADSB receivers for our own work that then feed into Mission Planner, just as an experiment. It's about 500 kilometers long and about 100 kilometers wide is the corridor that we see stuff. And that's meant that in a national park, agreed, the UTM, yeah, Geeksmania, hello.
Administering the
lovely to have you.
can
I would love to have you
to-
along. If I can send you a link, Geeksmania, perhaps you can email. I'll put my email address here. If you've got time, Gary at susnews.com. There's my email there. I will send you a link. I'd love to have you along for your reaction to this, if you're available. Where was I going with this? Yeah, so National Park on the mountains, Drakensberg Mountains here. And so we can see a lot of traffic, both Mode S and then also multilaterated Mode S and full ADSB tracks. And they were using it. They started using our system, which is as nerds, just to see the aircraft that had made incursions into the park and just give them a warning, because people go and fly around. There's beautiful things there, but there's also lovely animals up there. And there's other parks nearby where there are rhinos. Where am I taking this very long-winded story? I'm taking this long-winded story to, let's take the volume
an
up.
opportunity to disclaim that relief at any point. But I think it is too late for them to do that.
Is he furking still? I think he's still
And this
furking.
court can
Well, take it he's still furking. We are the only people here, Rory. You're in the room. Yeah, that's right. Yes, and there's no one even there in front of us to talk to us. We're still waiting for it to start. For those of you joining us now, welcome. This is the second case of the day. The one we're waiting for is the third case of the day. Back to that national park. Pull up a sandbag. So I said to a friend of mine that runs a UTM, Richard Parker, I said, come on, Richard, let's make sure this is nicely marked on Altitude Angel. And then we went to look at the data. And when we looked at the data of how the danger area was promulgated, it's actually promulgated 2,000 feet under the ground. So where I'm going with that is, before we start looking into UTMs, before we start looking into RIDs, on a paper map, it's easy to make it look right, because you haven't got the 3D space on that paper map. But the reality is, if you start looking at just base airspace, it's wrong. A lot of it's wrong around the world. And before we do anything with RID and anything with UTMs, we need to start getting that right. And I am on my super ranty high horse, but your local aviation authority should be the only person you get aviation data from. In that way, if it's wrong, at least it's wrong in the same way for everybody. It's nonsense. All these people standing up. This is Patrick's thing about apps. Standing up with apps. This app will do everything. Well, it won't if the data's wrong.
dispute about the certificate, because they were just talking about the funding structure that was set up in the Budget Act. And this court, I think we have to take those cases, understanding the way this.
No, we're still not there yet.
Yeah, I agree with you. Even, doing some work with the military and the GIS, and a lot of the times the target deck was underground. And people were like, well, we're working on that. And it's okay. If there's an IED out there and you're telling someone where to go and you're off by, I don't know, 100, 200 meters and it's 10 meters under the ground, I don't think that the usefulness kind of is eroded there. We'll work on it. Oh, okay. So, the best laid plans of mice and men. And
we've gone from a place of a flat map, which is a flat map, which is a flat map, to a 3D sky because of that cell phone app and whatever in the GPS within it. It's a whole new kettle of ball games, and the regulators just haven't kept up.
Yeah, well, most of them are not, aviators or technology people or reality people.
That, and it's happened in our case. I mean, that's often we have both.
That's not
Right.
is it? No.
I think the way this court described the claim in Delaware Riverkeeper, it used the word structural.
Yeah.
Bless their little hearts, but I mean, if I had a dollar for every person that told me that they were going to have a workaround, they were going to get around the FAA, this is not going to be a problem, we got it handled, this is the world's smartest drone, this is, and I know you've heard the same claims over the years, and unfortunately, people are they're just,
and each of the substantive
I guess, optimistic. I will say, people have had some friends in high places when Obama was in office. I mean, we had people; they had friends over there, and people chit-chatting to the White House and all the rest of that. And I still was like, even though you're calling the White House and you're talking to people over there, you still have these impediments. You still have what the FAA is going to ask whoever it calls. I don't care who calls over there. If the president calls over there, they're going to say, Mr. President, are you ready to take responsibility for the safety of the NAS? And I said, they're going to arguments. No, I'm good. Click. So
facial or structural
I don't think people really understand how this.
I read the district court decision there, and this, more importantly, this court's decision as saying that the court understood itself to be resolving the structural. And the arguments were made in district court in that.
Is this the next team?
That if there were as applied claims sort of encompassed within the complaint, that those were collateral attacks on the certificate and needed to be channeled through that process.
I apologize. I think I interrupted you. You got up and said you had 3 points, and I think I derailed you. If you very quickly want to address.
I'd rather answer your question.
If you very quickly want to address any remaining points you have.
Very quickly. Very quickly.
The third was to respond to your question about whether if a landowner lacked notice,
I think it's still I'm talking about certification.
Yeah, we're still a couple of moments away, aren't we? I'm gonna boil it lower just in case, because I have a hunch we're getting closer. Yeah.
Yeah, we are. And then so it's a safety, yada yada. But how many of these have these showstoppers have we seen, Gary? Remember privacy? Oh, God.
Well, this is let's put this properly into context. What Race Day Quads have done here. Sorry if I'm pulling a rope from under you, Patrick, but the AMA is not fighting this battle. They should be fighting this battle. There should be other FPV groups in America fighting this battle. There should be other AUVSI should be at this. It's taken.
Gary, this is one of these. So we just ran the story. One of these other, quad racing.
Yes.
Groups just got. But they just got the blessing from the FAA that they're sanctioned, which means nothing. But what it means is they just pulled the teeth right out of that organization. They're not going to say anything. We're some blessing, so now we can go out and get VC money.
Yes.
So this is what the FAA does. The FAA does is anybody who's like grumbly or grousing over there, they throw them a doggy biscuit and they go from watchdog to lapdog. And that's how it works. And the AMA hired Jim Williams to help them overcome the travesty that they had. With the 336, we're going to regulate you by unregulating you, and then you had the rest of the people that the FAA throw dog biscuits to stab the AMA right in the back. Want to listen to see if this is still FERC?
Obviate the need, or some other course of conduct that neither resolves the constitutional issue, which I understand your clients have a desire to have resolved, but that also doesn't implicate your client's property. So that's part of what we've, at least in our case law about these channeling statutes, have looked at, that kind of obviation or resolution of a presented constitutional issue.
Yes, Your Honor, it would remove standing from our clients, but the same would be true in Thatcher versus Tennessee Gas. The same would be true in Pennies. The same would be true in Delaware River.
Yeah, it's still FERC.
Water is interesting. Water is a bigger problem than we've got, isn't it, really? All around the world. Doesn't matter where you are in the world, there's problems with the delivery of water.
Well, growing population, water security, food security, broken down system. That's the deal here in California that they keep talking about conserving water or whatever. They grow nuts in the desert. They grow almonds in the desert. It takes 4 acre-feet of water to water them for a season. It's a lot of water. Anyway, so these groups that are supposed to be advocates and whatnot. I mean, AUVSI was bought off with the UAS symposium. I mean, NASA throws the same type of deal for free, but the FAA's got to charge. Or AUVSI charges whatever to educate the public. I don't think you could do worse by design, And I don't want to harp on EASA, but have you seen Donnie the drone?
Oh yeah.
For lack of jurisdiction.
Yeah. Well, I think this is the first Christmas maybe a little bit last, but last one almost doesn't count because the world was in even more of disarray due to COVID. But I think this is the first Christmas where aviation authorities around the world haven't had really big education outreach for people potentially buying.
I mean, look at Casey Neistat, and I don't want to harp on him either, but remember he did the flying elf thing? That thing has got, millions and millions and millions of views, right? And FAA puts out a video about holiday drone flying if you buy it, and it's got like 3,000 views,
Yeah.
It's laughable. And the same, I was harping on Donnie the Drone, which they should have named it Karen the Drone, but they got 20 some odd thousand views or something since it went up in 2018 or whatever, but they're kicking the FAA's butt. It's messaging that nobody wants to buy.
Can we what we also need to perhaps start thinking about before it is going to start, if you're just joining us, we're waiting. This is Jonathan and Race Day Quads are the third case of the day, and we're waiting for this one. Tell me again, what's this called they're talking about now, Patrick?
This case is federal. That's FERC and licensing eminent domain.
And Race Day Quads, who's going to be in the room when we actually get started? It's going to be Jonathan, Race Day Quads, and it's the FAA there.
I want to say the DOJ is going to defend the FAA. I could be wrong. I mean, FAA has their own kennel full of attorneys. But I think it's going to be DOJ. And officially, this is Tyler, and then I forget his last name, versus Steve Dixon, who's the administrator of the FAA. That's what the case is.
And then for those that don't know, quite strangely, to get a Freedom of Information request as a media organization is a lot easier than as a civilian, I think. Is that right, Patrick?
Well, I'm not going to say easier, but it's a lot cheaper. What they usually do, this is a funny thing too, because we're in the electronic age, right? So what they do is they charge you for research time. Some of the FOIAs that I've submitted have gone on for years. And so they have to put somebody on that, and that person researches and does all the legwork or whatever. So if you're not a media outlet, what happens is they charge you like for each page, they charge you for the time. And it can be in the tens of thousands of dollars. The bill could be $50,000 depending upon the ask. So it's prohibitive for private people or entities to get this information. In our case, they just stonewall. I've even had people in the FOIA office say, well, FAA managers come and tell us exactly what to type into the query. And I've had them come back, like I've asked for copies of emails. Oh, there's no emails to these people with that title in it. And I'm like, well, I know that's not true because I have emails and I emailed them with the subject matter in the title, you know. So you have to know what you're looking for or they stonewall you.
Bit of a gap here. Bit of a gap.
Okay,
Bit
then
of
we'll
a
probably
gap.
roll into our
Bit of a
case
gap.
of interest.
Shuffle, shuffle of papers. Shuffle, shuffle. Quick toilet break.
Crossing
Get
the
the beers
T's.
in. Yeah. Oh, yeah. I suppose you've got to write down whatever it is they've just done, haven't they? Of course they have. And okay, sorry, Geeks. Well, drive safely and listen along if you can. Lovely to have you here. So lovely to see you in the comments. We'll love to. If you're dull enough, you can join us on a Tuesday. You've got to get extra dull. And for recovery one drone, yeah, unfair is unfair wherever it is around the world. That's why we're interested in. I'm in Africa. We've got other guys in England. Bruce is in New Zealand, and Patrick, of course, is in America.
Case number
Here we go.
21-1087.
Eyes
Tyler
down
Brennan
for a
and
full
Maurice
house.
Desquas,
Here we go,
LLC,
everybody.
petitioners versus Stephen Dixon, administrator, and Federal Aviation Administration. Mr. Ruprecht for the petitioners, Mr. Ross for the respondents.
Yay! We should have had banners.
All right, Mr. Ruprecht, you can proceed when you're ready.
Thank you. May it please the court. I'd like to reserve 3 minutes for rebuttal, please. My name is Jonathan Ruprecht. I am the attorney for the petitioners. I am also a commercial pilot and flight instructor. Today, we ask this court to vacate the FAA's rulemaking and send it back to them. 2 reasons why. 1, the regulations are a violation of the Fourth Amendment. And 2, the rulemaking, it was arbitrary and capricious because the FAA failed to respond to many significant comments. As to the first point, the Fourth Amendment violations. People have a reasonable expectation of privacy in their backyards, and remote identification allows for law enforcement to track individuals in their backyard. In the United States Supreme Court case of Caro, the United States Supreme Court held that law enforcement monitoring a beeper inside of a person's home required a warrant. With remote identification here, law enforcement without any warrant, and it's completely unlimited, are allowed to track an individual in his backyard.
Wait a minute, Mr. Ruprecht, you're getting a little bit ahead of the rule. The rule does not create any authority for law enforcement to access any.
The rulemaking was specifically done in such a way so that there is no, it allows for anybody with a wireless electronic device such as a phone or a laptop to be able to actually receive the information that's broadcast. So it's public as well as law enforcement. So the states, the federal agency, law enforcement agencies, as well as the local law enforcement agencies could all receive this information.
You say could, but isn't there a need for some further authorization, enabling? I mean, they're requiring the
Got the word in 1 minute, isn't he? Or 2
drones
minutes.
to have this broadcast capability, but they're not opening access to the results of it under this rule, are they?
Well, how it's written is that an individual flying in the airspace of the United States is, and especially in a person's backyard, is going to have only 2 options. You only have to do a standard remote identification aircraft, or you're going to have to retrofit it with a broadcast module ID. And that information is going to go out, and then law enforcement can receive it. There is no middleman. There is no FAA that needs to be in the middle or court. It's just completely warrantless and unlimited in the ability.
Counsel, the rule says that there has to be a system of records notice promulgated before the data is. It appears that the system of records notice would even apply to the FAA's use of the data, but it would certainly apply
Tell them
to
it's
use
broadcast
by
open,
any
Jonathan.
other
Tell them it's in
government
open
agency.
and in the clear.
And that system of
Tell them it's in the
records
clear.
hasn't
Doesn't
been
matter.
promulgated yet, right?
Correct. That systems of record notice is discussed in the FAA's brief, specifically at the very bottom page of, I believe it's footnote 4. And at the very last sentence, there's a really interesting point that the FAA is actually presently in the process of updating that systems of record notice to allow for the FAA to disseminate the information that they have in their databases to law enforcement, but that is a completely distinct situation from remote identification messages that are broadcast out publicly. So it kind of looks like a pseudo response, but in reality,
you're making an argument about what's broadcast publicly. That is broadcast without identifying information, correct?
No.
Of the operator.
Correct. For purposes of the actual message element, it's a unique serial number ID that's going to go out. And so that information, everybody can get it. The systems of record notice on footnote 4, when they talk about it, that is specifically what's going to happen is going to be correlation.
Okay, but my point is, for Fourth Amendment purposes, your argument would then be that receiving real-time data that does not identify the operator of a drone is still nonetheless a search within Fourth Amendment purposes, right? That's your argument?
Yes, Your Honor, because specifically, even if the law enforcement did not have a, was not unable to actually real-time right then and there actually log that information into the databases and actually see the airman record, specifically what we've indicated in the addendum, you can see that there's medical records that are actually indicated there. We can see people's eye color and their weight and their hair. So setting aside they didn't have access to that, it allows for the logging and aggregation of this data. And then all you have to do is just pair it up. Public property records, now I know exactly who lives there based upon public records. And I've seen that unique serial number. It's not randomized or anonymized. It's a unique serial number that traces around across the United States. You log it, and then you can go back and actually search the archives.
Which a computer would take us microsecond to do.
There's lots of ways where public property records, et cetera, that are public and searchable and whatnot can be used to aggregate. But what's your best authority for the proposition that once law enforcement performs such aggregation of public information, it becomes a search?
I'm sorry, can you say that again? What's my best authority in regards to when law enforcement aggregates data?
Law enforcement could follow a car and then see that it stops at a particular in front of a particular house, and the person goes into that house, and then they can look at property records to determine who owns that house. But that doesn't make all of those observations a search, and does it?
I think you're primarily getting into an interesting point there in regards to the observation of one individual at one particular location and what law enforcement could observe at that one instance, right? So this is much more voluminous and persistent. It's primarily going back to what was primarily discussed in the Maynard case at the DC Circuit, where it's the whole of the movements, that an individual has a reasonable expectation of privacy in the whole of their movements. But that's also a distinct issue from a person having a reasonable expectation of privacy within their own home. And in the Caro case, they did track that beeper in the can through multiple houses, but Caro, in his house, that was for a short period of time, while remote identification, this is unlimited and unwarrantless. There's not an end to this regulation. It's just persistently in effect.
Mr. Ruprecht, I understand that you reject the analogy to a license plate, but just for purposes of probing your initial set of points, a license plate is visible to the public, and when paired with other information, you can find out a lot about a person. You know who it is, if the car is parked in the driveway, who the person is who owns the car. Therefore, are they visiting that person, or are they the homeowner? But the key there is that the public doesn't have unfettered access through that number to the further private information. And my understanding is that this rulemaking similarly doesn't open the door generally either to the public or to law enforcement for the information associated with the remote ID. Am I wrong about that?
So there are two aspects here. There is the broadcast elements from that are required by regulation. That's a unique serial number, and then it gives the lat and long. The other issue that Judge Wilkins was bringing up in regards to the FAA databases, which the FAA is also updating the systems record notice for, that is the databases that the FAA has for example, if you go and obtain a remote pilot certificate or a medical certificate, it puts your birth date, your age, your weight, your hair color, all of that information. And so those are kind of two separate distinct points. So just
but I take your objection is to the public or law enforcement's ability to put those two pieces of information together, to use the public-facing unique identifier to access personal information in a database. That's your concern, your privacy concern. It's not just that there's a unique identifier being broadcast.
Well, actually, the unique identifier, that's actually the most dangerous portion, and that's what's publicly available. And so as long as you can have that and aggregate that over time, all you have to do is figure out matching those up, and you've identified this individual over a really long period of time. And I see my time's about to potentially get up here. Do you guys have any questions?
No, thank you.
All right, thank you so much.
We'll hear now from Mr. Ross.
I think it got derailed on the whole arbitrary and capricious thing got skunked.
Thank you, Your Honors. Thank you, Your Honors.
You can raise is if you want. There's a button on your right. Bring it up, and that'll actually help the amplification and the recording. If it's
better.
He didn't make enough of it's public, i.e. any smartphone can hear
Thank
it.
you, Your Honor. Kason Ross for the United States. Following Congress's prescription to establish rules allowing for the remote identification of unmanned aircraft systems, the agency issued the rule challenged here to allow for airspace awareness, to distinguish compliant airspace users from those that may pose a security or safety threat.
How are you defining airspace in the petitioners or the plaintiff's brief? They're objecting to authority to regulate down to the ground, to regulate within people's private property. They say this is as if, the Coast Guard is regulating the rowing of a boat on someone's private pond. What's the scope of the FAA's authority to regulate so-called national airspace?
Sure, Your Honor. For one, I actually don't understand the petition itself is challenging FAA's statutory authority. I believe they concede, as a matter of fact, FAA's direction under Section 2202 of the FAA Extension Safety and Security Act of 2016 to actually issue these rules or rules of this sort. But in any event, FAA exercised that authority under 49 USC 44701 A5, which provides the agency authority to regulate air commerce or the means necessary to ensure safety in air commerce and national security, as well as 49 USC 40102 A3, which provides the agency additional authority to regulate aircraft operations which could directly affect or may endanger safety in air commerce.
So is it the FAA's position that it can regulate down to the ground and over private property?
This case doesn't raise that question, Your Honor, and petitioners' arguments to the contrary in their reply brief are not worth addressing in this case. But instead, it's the regulation at issue here was simply pursuant to the regulation of air commerce.
rules. And courts that have addressed this question, which we didn't raise in our brief because we didn't understand.
When would be the case to address?
Sure. So I can point the court to Hill v. NTSB.
No. You said this is not the case to address Judge Pillard's concerns.
Sure.
You're getting a bit derailed now.
And the petitioner's concerns about regulating drone use below the tree line on private property. Could someone bring an as applied, let's say we rule for you in every respect.
Right.
Down the road, could someone bring an as applied challenge on Fourth Amendment's ground to the FAA's tracking someone's use of a drone on their own property, particularly when the drone is on the property below them?
Certainly, Your Honor. And there's nothing in the rule that would foreclose that sort of challenge in some sort of defensive posture. Courts adjudicate motions to suppress all the time on Fourth Amendment.
No, we're not talking about a motion to suppress. And let's suppose that there's just no enforcement action at all. So it's not even a defense to an enforcement action. It's just that somebody a year from now buys a drone and they want to just use it on their 100 acres in the country. And that's the only place that they want to use it. And they don't want to have to transmit their remote ID data to the government. How can they bring that challenge?
I think at that juncture, Judge Wilkins, absent any other government action, they wouldn't have the ability to do so. Congress has channeled challenges to FAA rules to be within the 60 days the rule is promulgated. So unless the agency takes some sort of enforcement action against that ranch owner, I don't believe they would have any ability to challenge it a year from now.
Then what is the government interest in obtaining remote ID data from a drone that's operating entirely on one's property?
Because, Your Honor, it's easily foreseeable for the drone to be operated outside of that person's property. For a drone to traverse a fence line to an adjacent property owner's space is very foreseeable. An anecdotal example might be illustrative and helpful in this circumstance. In 2015, I'm told that a very sophisticated drone operator was piloting his drone in Gallery Place, just a few blocks from here, and a quick gust of wind caught the drone and took it to the White House lawn, completely out of his control, and he was unable to keep the drone from essentially creating a national security risk. Additionally, the rule itself is forward-looking.
So how did RID help that
So
then?
your argument, just to cut to the chase, is that
Sure.
even if there is no government interest, or the government interest in obtaining data for a drone operating entirely on one's property, is that the person may not continue to use the drone solely on their property. And so for that reason, you can't just kind of turn on or off the location, I guess, technology. It has to be on at all times unless you're in one of these FAA authorized identification areas.
That's correct, Your Honor. There's nothing for FAA to preclude a drone user from using his device absent his property, similar to a vehicle license plate, for example. If someone there's nothing local law enforcement can do to foreclose someone from using their vehicle, which is perhaps not covered by a license plate, outside of their property. But the regulations exist requiring license plates to provide for safe identification of those vehicles on the roads.
Let's say I don't think that's a good enough reason. You have a second? Let's say I don't think that the concern that someone on, as Judge Wilkins said, a 100-acre farm, or we could imagine it, 10,000 ranch, might, in the middle of that ranch, somehow accidentally fly the drone 5,000 acres the wrong way over a property line. Imagine, I think that concern is not a good enough reason to regulate what someone does on his own property. You have another reason?
Sure. What I was getting to previously, Your Honor, is that the rule itself is forward-looking in the sense that FAA and Congress foresee a rapid proliferation of drone use. I think
We've all seen models of Amazon drones, for example, delivering packages to our doorsteps, or drones of other sorts being a greater portion of our public life. And in this way, when drones enter a person's property, the FAA is aware of where the drone is if it poses a safety or security risk. Very similar to traffic management and for planes in the sky, for example, FAA is able to identify and avoid collision between planes. Similarly for drones, even if one particular ranch operator, say in the middle of Oklahoma, is using his own drone, that's not to say there might be another drone that would foreseeably collide with that drone, but it would be impossible to know that there was other.
What if I'm talking about on your property below your tree?
Even so, say there was still another drone that was coming into that space for one reason or another.
Would that other drone be trespassing?
That would be a separate question to bring an action against the other drone user.
A little bit extreme to say you can regulate what someone does with their drone on their own private property, because what they do on their property might interfere with what a trespasser does.
That may be the case, Your Honor, but I will return to my prior point that there's no way for FAA to foreclose any drone user from exiting their property with the device. And that's really
it could make the regulatory requirement that anybody who's not below the tree line on their own property needs to have this. And then if you're out and you don't have it, then you're not in compliance. I mean, there's lots of ways that this could have been written more narrowly. I recognize that isn't the rule we have, and this isn't actually the nature of the challenge even that we have before us, but we're just probing the interest of the FAA behind this particular rule. And it does seem difficult in some fact situations to correlate the interest that you've stated and that we see in the administrative record with some of the applications.
So I will direct the court to pages 4415 to 16 and page 4437 of the text of the final rule itself, in which the FAA addressed possible proliferation of so-called FAA recognized identification areas, which Judge Wilkins previously noted. And in that circumstance, specifically considered whether there should be effectively exempt areas, as you've questioned, Judge Walker, in everyone's backyard. But allowing such an exemption would completely undermine the rule's effectiveness. Consider, for example, a series of backyards that are adjacent to one another. If all of those backyards are exempt from the rule, then there would be effectively blind spots for the FAA.
And maybe it's unfair to expect the regulation to be tailored this narrowly. But I'm imagining there's a TV show Yellowstone, and they own a ranch that's it's the size of Rhode Island.
Mm-hmm.
None of the concerns you're talking about would apply there.
That might be true, but there's no way for FAA to tailor the regulatory approach here to be so specific in that way. And so rather than
tailor it, I think you'd have to make an argument that they don't have to. And I'm open to that.
I think I understand, but and it's not to say that someone of the sort that you're identifying might still be able to request an exemption from the agency. And if that exemption were denied, there could be subsequent administrative proceedings contesting that denial, or some proceeding in which the FAA cites someone for failure to comply with the rule, and they challenge it on precisely that basis.
This rule does not foreclose the possibility of someone being granted a sort of safe fly zone, no reporting space on their own property?
I don't want to overstate the possible exemptions from the rule. My understanding is that it provides for exemptions in these FAA recognized identification areas, primarily for community-based or educational institutions. But I'm not sure that.
I thought the rule said that those things cannot be applied.
Oh no, those exemptions are still available. So
for someone's private property.
That's what I'm saying. I don't want to overstate.
And there are not very many of those. It was the commenters were concerned there were not very many of these FAA recognized identification areas. So, but you said there might be some process for an individual getting an exemption if they had.
I'm
not aware of that.
I don't want to overstep, but it's certainly feasible, I think, or foreseeable that were the FAA to bring an enforcement action for someone's failure to comply with the rule, the response would be, I'm not going to broadcast my identification when I'm on my 100-acre ranch. And that's not foreseeably within the context of the rule, and FAA could consider that defense in the normal course. That's obviously far away from the nature of the challenge actually presented here, which it sounds all agree are squarely within the agency's statutory authority. I see I'm over my time, but I'm very happy to answer any of the.
I have some more questions.
Absolutely.
So, with respect to the remote ID data and the operator data, can people within the FAA right now that the rule is effective access that data in real time? So in other words, be able to see the data transmitted by the drone and then access the FAA records to match that with an operator. Can that happen today?
I believe so, Your Honor. And the government did not raise a ripeness argument with respect to the petitioner's challenge.
But that can happen today, even though a new system of records notice has not been promulgated, right?
That's correct. The new system of records notice is for other law enforcement agencies to be able to have that capability. FAA can do that now. That is, pair the serial number or session identification number of a particular drone with the personal information attached to that device.
That's the way I read the kind of oblique language at pages 11 and 12, and I think it's 36 of your brief, because it didn't seem like you wanted to say that out loud explicitly. So I'm glad that we now have that clear. So now that we have that clear, isn't that a search within the meaning of the Supreme Court's decision in Cairo?
No, Your Honor, because the Supreme Court made clear in Cairo that there's a salient distinction between attachment or installation of a device versus the actual monitoring of the device.
But you just told me that the device can be monitored today by the FAA.
But there's not evidence that the monitoring has actually taken place. Indeed, the Supreme Court's decision in Jones underscores that distinction. That is, the Supreme Court made clear in that case.
Why in analyzing the rule that gives the government the authority to do that, do we care whether we have evidence that it's taking place or not?
I think that's because the actual monitoring is maybe what would constitute the search, Your Honor. Indeed,
but the rule authorizes the monitoring to take place. So to construe the constitutionality of the rule, don't we have to assume that the authority that is granted the government by the rule is being exercised by the government?
I think the court would assess the constitutionality of the enforcement of that rule in the normal course. In Kansas v. Glover, for example, the Supreme Court passed upon the evaluation of whether it was a search to query a license plate database and concluded that it was not. But it did not press upon the threshold question, or there was a separate threshold question of requiring license plates and establishing the license plate database in the first place. And so those are two separate.
You're telling me that a rule that authorizes the FAA in real time to monitor drone use of citizens in their backyards and exclusively on their property, that we shouldn't consider whether that is a search within the meaning of the Fourth Amendment because we don't have any evidence that that is actually occurring now, even though it's authorized to happen by the rule?
For one, yes, that's correct. Second, Your Honor, the First, Fourth, Sixth, Seventh, and 10th Circuits have all held that pervasive and long-term video surveillance of a home does not constitute a search. Indeed, the Seventh Circuit in Tuggle explained that 18 months of surveillance in which 3 separate poll cameras were directed at a home did not constitute a search under the Fourth Amendment. this is a much less invasive form of data collection. And indeed, my understanding, based on my conversations with the agency, is it's not as if there are individuals.
If the Supreme Court held in Cairo that it was a search once the government monitored the data from the beeper that was installed in the can, then why isn't this a search?
Well, in Caro, of course, Your Honor, the actual case involved an enforcement action taken against Mr. Caro. And so
Enforcement doesn't make it a search or not. We don't care. Teachers who search a backpack at school, that's still a search within the Fourth Amendment, even if law enforcement isn't involved. The search is a search.
So if you're sufficiently skeptical on this score, we urge the court to recognize that a special needs exception applies here, such that a warrant would not be required if you conclude that it is a search. The amount
Tell me
of
why I shouldn't conclude that
Safety
it's a
and
search
security.
under
He's
Caro.
going to say safety and security.
Sorry, Your Honor. I was taking our disagreement on this score, and I
I
wanted to.
understand you have the fallback position of special needs, but tell me why I'm wrong about Caro if that's what I'm inclined to believe, that it's a search under Caro.
I guess I will reiterate the distinction in Caro between the installation and subsequent monitoring. And
Well, the question is whether an individual has an expectation of privacy. I would assume, I would trust that the FAA is looking at the information it's getting, because that's the point of having the system in place. If there's somebody who reports that there are drones, hovering outside their bedroom window, you would assume the FAA is going to look, well, who's flying that drone? And so then the question is, does the person who's flying that drone have a reasonable expectation of privacy in either the location of the drone and or the location of the drone operator? And I took it in your brief that your position was no, that they did not have a reasonable expectation of privacy, notwithstanding, for example, Caro, Carpenter, Jones. And I guess that's the question that I think that Judge Wilkins, although he can press his own point, is probing. Why no reasonable expectation of privacy here?
sure. So there's also the threshold point, Your Honor, that the 5th, 8th, 10th, and 11th circuits have said that there is no reasonable expectation of privacy in the location of a plane. That is true whether you are a passenger or pilot of the plane. And
they're talking about at least special aviation and commercial aircraft. That's something you can see from thousands of feet away, not a drone.
Depending on the circumstances, Your Honor, you would be able to see a drone from potentially thousands of feet away, depending on the size of the drone. But additionally, the Supreme Court held in Knotts that there is no reasonable expectation of privacy with respect to your public movements. And so both of those doctrines intertwine here, such that you do not have a reasonable expectation of privacy when you avail yourself of public activity. And so that is why there's no search here. I think, to return to Caro, is that my understanding is that the simple monitoring absent subsequent enforcement action would not present a search at all. And because there's no actual law enforcement action taken, then there's no ability to raise a Fourth Amendment claim, so far as I understand. And
is that because you think they wouldn't have standing? The violation of privacy is a violation of privacy, even if no sanction attaches to it. And if everybody who works at the FAA knows all kinds of things about, you could station somebody on my front porch. The letter carrier could stand on my front porch and look in my front door window all day long. And the fact that I'm not being, prosecuted for whatever activities going on inside doesn't mean I don't have a privacy claim. I don't know. I think that you're confusing maybe the opportunity to raise an objection with the existence of the search in the first place. And I'm just not sure why it would be limited to an enforcement action if the FAA is in fact getting information through the remote ID program. You have to answer the question whether there's an expectation of privacy in that information, enforcement or no.
I suppose we're confusing two separate questions here, Your Honor, which is that whether the rule itself violates the Fourth Amendment versus Fourth Amendment standing doctrine, which is,
Right, and I think
I
we
apologize
were-
if I confused those.
Right. In terms of the petitioner's claim that the rule itself violates because it gives access to law enforcement, there I think the rule itself does not yet. And then in response to Judge Wilkins' questions, you acknowledged, but the FAA, in its sort of enforcement role, it does have access to the information. It can pair the remote ID information with more personally identifying information. And that's something that this rule authorizes.
That's correct.
And so to the extent that that's what is out there in privacy terms, the question there, I guess, is does that infringe any reasonable expectation of privacy? The fact that all of FAA or some people in FAA with some privacy protections do have access to that.
Correct.
And your response to that is?
It's still not a search because the availability of that data does not infringe a reasonable expectation of privacy for the number of reasons that I've said. The location of an airplane, your public movements, the fact that the Supreme Court said in Kansas v. Glover that running a license plate itself, so basically what FAA would be doing with the drone data is not a search. And if you disagree on all of those scores, we do have the position that, or suggest the court deny the petition on the basis that their special needs apply here, such that right now there's no way for FAA or its security partners to identify drones in the air. And this particular mechanism is.
Let me ask one question, but it's with apologies. It's a bit of a long wind up.
Sure.
It's going to end with this question: what do you want me to do?
Right.
Now, assume I think that this rule does not violate the Fourth Amendment in 99.9% of its applications, because although Carpenter and Jones carved out some, I think, still narrow exceptions to this general rule, there is, I think, a general rule that what someone does in public is not private. And most of the time, I suspect, when people fly drones, it's in public. Now, even for the sake of this, say that above your own tree line will count as in public. But there are going to be times where someone might not even leave the walls of their house, and they're flying a drone on their own property below the tree. And that drone and that person cannot be seen by anyone unless someone were to trespass on their property. In that instance, I think your rule is unconstitutional.
Mm-hmm.
What do you want me to write in an opinion if I get to write this?
Sure. For one, I will contest that I don't want to fight the hypothetical.
I know,
but I will say just for purposes of clarity with respect to the rule's scope, in all circumstances, it contemplates that operators will be within the line of sight of a drone, and so it's hard to imagine that you would be within the walls of your house and operating the drone outside. And so even if you're at the window and
we'll take them outside the house. I still think
sure. Yes, absolutely. I just wanted to clarify for purposes of the court's understanding. My understanding is that the rulemaking would have to be done again because the technical specifications associated with identifying very specific places in which the rule would not apply are things that would require substantial reworking of the rule itself. That's my understanding.
Would it? Or is it not that this is in effect a challenge to the rule's legitimacy, and you're saying that's an application that might be invalid?
Sorry, I'm trying to be candid with the court, Your Honor, just to say that
I'm grateful.
There's in the very small circumstances which you've identified, Judge Walker, that the FAA's application of the rule does not contemplate that sort of surgical tailoring, such that they would have to reevaluate how to implement the rule itself. That is my understanding based on my discussions with agency counsel.
Is the data, location data, is it stored?
No, Your Honor. And that's where I have another response to Judge Walker's question with respect to Carpenter and Jones, is that the data here is different in kind and different in degree. Because the remote ID rule only requires drones broadcast their information while they're operated, there's a very limited universe of information implicated here. So it's different in degree because people use their drones much less frequently than say there's
Different. If you use it, if I used it 2 weeks ago, does FAA have the ability to go back through its database and say, oh, on that Wednesday afternoon, 2 weeks ago, Judge Pillard was operating her drone at Fort Reno?
No, Your Honor, and that's why it's different in kind.
Okay.
Is because FAA does not store the data, and indeed, so far as I understand, have not contemplated the ability to store that data. They have
All right.
neither.
Other questions?
Thank
you. Judge
I have,
Wilkins?
yes. I'm trying to understand your response to the, I guess, arbitrary and capricious or working challenge regarding statutory authority. So the rule cites two different statutes as, I guess, providing the authority for, and you referred to this when you opened.
Yes, I believe it's
40103B1 and B2. And that statute talks about navigable airspace, right?
yes.
And is there a definition of navigable airspace that you can point us to?
Yes, Your Honor. It's 49 USC 40102A subsection 32.
Okay, that's what I thought you would point us to. And it says airspace above the minimum altitudes of flight prescribed by regulations under this subpart and subpart 3 of this part, including airspace needed to ensure safety in the takeoff and landing of aircraft. So where are the regulations that define minimum altitudes for drones?
I believe it's cited in petitioner's reply brief. I'm sorry, I don't have that immediately available. I believe it's 49 CFR 119, but I'm not positive. But that does not, the court need not address that issue here. I will return to your, I think the question on the.
I want you to answer my question though. I take your point that you think that we don't need to answer it, but
and that's
assume that I think that I do need to answer it. So how do I know what navigable airspace is? Is there a regulation that says
Did we
that
expect this?
navigable
This has
airspace
been
goes
our
all the
whole
way
problem
down
the whole
to
time.
the ground in
I'm waiting
someone's
to hear.
backyard?
It certainly could foreseeably include that, Your Honor. That's, for example, how FAA regulates language about a flight attendant saying that you need to wear your seatbelts and put up your tray tables while you're on the ground in a plane. And similarly here, drones could foreseeably interfere with aircraft operations on the ground.
I thought there was a reg defining navigable airspace as 500 feet up. Am I misremembering?
No, you're not misremembering, Your Honor. I just didn't have it available. But
then
He just agreed it's
I don't want to speak for
500
Judge
feet,
Wilkins,
didn't he?
but this
So
question
no
made me
Cessnas
think
below 500
if the
feet.
reg says navigable airspace is 500 feet up, and if Congress has authorized the FAA to regulate in the navigable airspace, where's the FAA getting the authority to regulate 500 feet down?
In two places, Your Honor. First, its authority to regulate air commerce, which is 40102A3, which is a separate substantive question than the navigable airspace. But also because the statutory language for navigable airspace includes, quote, airspace necessary to ensure security in takeoff and landing of aircraft.
Isn't there also a concern of much lower altitudes with drones that if a drone, for example, would run out of power and it would just drop? If it's 50 feet up and it drops onto a pedestrian's head or an expensive vehicle, it could cause a lot of harm.
Absolutely, Your Honor.
So the 500 feet, I don't understand this rule to be constrained by that.
That's correct.
Other questions?
No, not for me.
All right. Thank you, Mr. Ross.
Do you think that's it?
Should be a rebuttal. 3 minutes. Jonathan should have a rebuttal.
The multiple cases that were pointed out by my opposing counsel, specifically regarding the aircraft flying around in the United States and the transponder cases there, a lot of them all had on the underlying factors going on with it's the Knots case. And what's interesting to note there is that these are kind of like short, they're not short, but there's like a one-time flight here to there. It's not a persistent surveillance. And what's interesting to note is that if Knots is the great granddaddy of those cases that are in other circuits that are non-binding to this court, the DC Circuit said in the US v. Maynard case, specifically it titled one of these subsections saying Knots is not controlling. The great granddaddy case for all of the cases cited by my opposing counsel was specifically distinguished in that case. And so I think that's one really important point. Two, regarding, there's a Fourth Amendment analysis we've been going into here, and the court has been very asking a lot of probing questions on. But I noticed that I was just counting the minutes there that my opposing counsel spoke. There was about 27 minutes there of Fourth Amendment questions. And I find it really interesting that, and I think a really good quote here is from the State Farm case where the United States Supreme Court said, courts may not accept appellants' counsel's post hoc rationalizations for agency action. There was a whole lot said in those 27 minutes trying to rescue this doomed ship, this Fourth Amendment case, but the record is they had an opportunity and they didn't bite at that apple. And so the only proper remedy here is really we need to hear what they have to actually say. And in this court, this is not the proper forum. The only proper
I'm not sure
remedy.
I understand your argument, counsel. Are you saying that the rule itself, when it addressed the Fourth Amendment questions, did not make the argument that even if this is a search, it would qualify under the special needs exception?
The special needs exception was never discussed. I see my time's up, Your Honor, but I would love to get more into this. The special needs exception was never discussed in the final rule.
Okay, so that's what I'm trying to understand. You're saying that if it can only be justified by the special needs exception, that justification was not articulated during the rulemaking.
Correct, and even more so, there were numerous commenters that pointed out Kotz, Jones, and Riley. So specifically at JA 1049, a Cyclone FPV cited and applied the Carpenter and Jones cases specifically to the NPRM. An attorney named Thomas Sugahara at JA, I believe 1063, went through and discussed Carpenter, Katz, Jones, which Carpenter discusses the rest of those cases, Katz, Jones, and Riley. And in response to those incredibly on point comments regarding the Fourth Amendment, the FAA did not provide any response in the final rule.
All right, thank you. I don't have any further questions.
All right, thank you, counsel. The case is submitted.
Thank you, Your Honors.
Oh, well, there we are then. Is that it? That is it, isn't it? Right, let's stop that then and stop sharing. Well, what do we think? I mean, it sounded to me like they had a bigger turn than Jonathan. And yeah.
I do. And, I have some issues with, and again, maybe being a little bit older and through the civics class and all the rest of that, but this idea that, your privacy takes a back seat to a special need that wasn't even, justified or described. And, nobody's keeping the data. Now, I thought that they were going to log this so they would be able to use that for enforcement actions. So, it's one of those deals. So if it happens and nobody catches it, so I don't know that I believe that. But anyway, I don't like the overreach on the assumption that my rights or the privacy are going to take a back seat to possible enforcement actions, especially when we already have registration and there's only been 70 or plus or minus in enforcement actions using registration. I think a lot of the arguments, the other one that, oh, this is going to grow and there's going to be tons of drones.
Yeah. Oh, yeah.
And you don't want to, he doesn't want to fight the hypothetical, but he's throwing hypotheticals out there like they're anybody. The other thing I didn't like is he had 27 minutes and all they kept doing was interrupting Jonathan. And I would say that Jonathan had less than, 10 minutes of actual time to present his case. He didn't even get to talk about the arbitrary and capricious part of this, really.
Well, I think, and I'm very glad Bruce has joined us. I think the most interesting thing was the trying to redefine navigation, or whatever it's airspace. You know what I'm trying to say.
Navigable.
That got out again. Navigable. There's some word like that, and I've never got a bit. Because that's been the nub of our problem for 20 years.
Because that was really interesting, because they said under 500 feet, but then the FAA had to do this. They had to go, but if it's landing and taking off. So does that mean then, theoretically, remote ID might be wanted in or around or at an airfield, but everywhere else, forget it. Because it's not. Yeah, and that would make, but remote ID, yet again, it's so hilarious. The FAA guy was so funny. He should do stand-up. He should actually go and do stand-up, because he said...
I believe he should.
Because he was talking about aviation and knowing where everything is. The FAA has not got a Scooby-Doo how many planes are in the sky at any one point, or microlights.
What was it?
Idea.
No, but they lost 6,000 or 7,000. Was it even 9,000? Patrick will probably. There was a huge number they've actually lost. I don't know where they are on the register.
Oh, you're talking about? I think it was like 90,000 missing aircraft.
Oh, was it 90,000? Oh, okay.
Bermuda Triangle.
Well, what happened?
Triangle.
They had to gin up the safety numbers, because they have a safety of the NAS thing every year, and basically they added aircraft that had been registered in the last 10 years. Shenanigans. But, the point that was made about, this airspace definition, I wish this guy would have said, it's down to between the airspace and the blades of grass, because they would have sounded like they were totalitarian. I can't family shows.
Did he not get the guys, you've got a huge bit of land, nobody should be able to see you when you're flying on your huge bit of land because it's miles from the road and you're outside and you're flying. Did he not get that? Of course, a Wi-Fi receiver could hear what you were doing in it. And for those joining, I understand that what I don't understand wasn't unpacked was the fact that you'll be able to see the position of the operator. Because to say somebody in the aeroplane is no right of privacy, but you don't know where the pilot's car's parked. That's a little bit tenuous, but that's what you kind of know with this. You know where the pilot's car's parked, and you know where the aircraft is.
Well, the other thing, though, that they mentioned that no one would be flying from inside their house because you have to fly line of sight. But I thought a remote ID was supposed to enable BVLOS.
So,
yes.
And go ahead.
Well, I was going to say, so we know the pilot's in the plane. Okay, so you know his rough location. You don't know if he's in the cockpit or not.
No.
He could be somewhere else on that plane. He does not have to be sat in the cockpit, because there could be someone else in the cockpit flying the plane. A log hole.
Yeah. In Russian airlines, it's usually the daughter of some important person flying the plane.
Yeah. But I think we've really got to get the knowledge, piece out that anybody, we're not. I don't actually give a fig if the FAA or the police know where I'm flying. Anybody with a smartphone can know where I'm flying. Anybody. And a group of us. So here we are, we'll have our home PCs, we'll have our smartphones on, listening via Wi-Fi when we're going out and about. We'll feed all that data into somewhere. And we this is a lot easier than decoding aircraft with ADS-B. It's any bloody Wi-Fi device. We'd soon get a database of what's happening.
The other, this guy's talking about 100-acre ranches and all the rest, and that's nice, if you can afford the big ranch. But I'm a work-a-day Joe guy, and I can't even fly. I used to be able to fly in my backyard, but now I'm closer than 5 miles to an airport, so I got to get Lance to fly in my own backyard, and that is below tree level in my yard. I got some huge trees there, and I can't even fly in my own yard. So if I want to go test something, I just put something on my drone, whatever it is. I don't know, a banner, whatever. And I want to go out in my backyard and I put it on the picnic table and start it up. Somebody can know that I have a drone. I've been in situations where I've flown on my own property and I've had people come running out, and I'm calling the sheriff and blah, 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 go nuts, do whatever you want to do. But am I going to be dealing with people that want to come and harm me, steal my stuff, maybe steal my secret sauce and how I'm operating if I'm commercial?
Exactly.
There are so many issues here. And just to give all of that up, because maybe someday there might be some action where the FAA needs to monitor somebody in real time, which they probably won't even know that they're there. None of this makes any sense.
And just touching on what Patrick said about commercial operations there, when RIG was announced in the UK and it was coming, I did actually email the DFT and says, right, how will you protect my commercial operations? Because when I'm flying my aircraft and I am doing specific tasks, we have a certain way you fly and operate. So your flight path is very, very much specific to the task you're doing. You don't want to tell other companies how you capture such good data. You don't want that information out there. It's your USP. It's what you can sell to your clients. And RIG just will give everything away. It'll give who you're flying for, what company, your flying style, how you capture the data. They don't grasp the commercial destruction it could technically do to commercial operations. It is astounding. But I put this to the DFT in the UK, and this is one of the things I email says, how are you going to protect my data? How are you going to make sure that my competitors will not know what I am doing? How are you going to protect me? Because I need to know.
You can't, and you are correct about that. That's how you do things, and especially people that have been in this business for a long time have developed techniques on capturing that data that they need. Or what if you're a competitor or even somebody with nefarious activity? I'm working. That's all hypothetical, but I'm working for some sort of power plant or refinery or whatever, and I'm doing, and if someone wants to be nefarious, hey, that's the time I'm going in with my RID off to do my, and I'm grasping at straws, but I don't think that the benefits outweigh the risk. And the other thing that I didn't like on this deal is they're like, oh, well, you could go to the FAA and petition. Well, I got to go and prove and petition for my right that's guaranteed in the Constitution. That's bull crap. The other thing I didn't like too is this, comparison to a license plate.
Yeah.
The aircraft already have registration on them, but the license plate is not broadcasting.
We've had every house as it went down a street couldn't. If everyone's home router was listing out, everyone down the street would know the car's gone by.
That, and we had cases here in California years ago where it used to be you could kind of public information, and it was easier to have someone's license plate run, and there were privacy issues with that. And I do believe, if memory serves correctly, that people were murdered, and information was given away and where they lived and things like that. So I'm not going to say that that's going to happen here, but it does open up issues, and we got a lot of nut jobs. Not only here in the United States, but all around the world. Well, I don't think you're that kind of nut job, Bruce. I know you're nuts, but not that kind.
Well, don't take this the wrong way, Patrick, because obviously, I know you Americans love your freedoms and you're very, very much, yeah. Well, you guys are very much into your weapons and your handguns and your firearms and everything. My fear would be if I was flying in America, I'm willing to bet if this came through, within a year, there'd be more than one shooting of a drone pilot. I would absolutely put money on it. No one will die from a drone being flown. It'd be from flying the drone itself, yes, but actually the aircraft falling out the sky and hitting someone, no. You know what I mean?
I love the fact that falling drones only hurt expensive cars.
Yes, I thought that was interesting. And what was also interesting, when they said about aircraft falling out the sky and hurting people. Well, how many people have died so far, guys? Can we just do a quick check? Because I just need to have that number in my head again, please. Can we? How many?
And I missed the part of the remote ID spec where it mitigates that.
There's none of that. And this is another deal. If we had a watchdog advocacy group that wasn't like being paid off to do, a symposium for the FAA, they might go after that. And people should talk about that. That was one of the things with the AOPA. Hey, we need an equivalent level of safety from drones. We just can't let them fly until we have that. And now we've come full circle and we've got the data. And you've seen in the United States here, people are crashing into houses, into buildings. People are dying. We've got skin in the game. Yeah, you got skin in the game, but so did the other 3 people in the aircraft that crashed in the fog where you shouldn't have been flying. And you're talking about these safety risks with drones. I think they're grasping at straws. Why aren't they enforcing the laws and the FARs that they already have? Why are we being so punitive to this new aviation? And we know it's not because it's a safety issue. That's horse crap.
Yeah, and I absolutely agree, Patrick. Keep pushing the safety issue, and I think we deservedly can take the piss to a degree.
We'll win.
Because we're safer than manned aviation.
It's self-evident, and I've talked to people that are actually making money about giving me some money to do some reports that you can actually take to people in Congress and go, here you go, look right here, you look at the data. Nobody's dying. You got all these aircraft, you got all these flight hours, and people, and I don't want to beat up on manned aviation, and I'm wondering what they're going to change the nomenclature for manned aviation because, we're going at crewed. Yes. I don't know what manned is. Is it going to be personed aviation? I don't know. But that data is here and there's no disputing it. And you could show it. The other thing I thought was totally irresponsible is that notion that a drone on the ground could be dangerous to aircraft. How could a drone sitting on the ground be dangerous to aircraft?
Well, it could be something on the runway.
It distracts the airline pilots.
It distracts people. It sits on the runway waiting for someone to run it over to get a puncture.
Well, in my backyard or, at the park or whatever. The other, thing with this flying at these locations with the CBO or whatever, I don't want to have to pay $100 a year to go fly or, go find my enjoyment or my hobby. I want to go to the park. I want to be in my yard. I want to be on my property. I want to be on my friend's property, whatever. And now, I have to incur costs and an erosion of privacy to fly the plane. It's crazy.
But, the real sort of, I want to sort of round this up and then edit it down for those that join later. But the real, the real thing is, it shouldn't be down to race day quads to be jumping up and down and making a fuss. This is the biggest thing. None of us think everyone here is for safety, even Bruce. We all love safety, nothing wrong with safety. We don't want to be flying into airliners, all that sort of thing. None of us here think remote ID is a good idea for lots of reasons. We might need something like it one day. We might need it near airports, whatever. If you need it to fly commercially there, then all great. It needs to be a level playing field, but it is ridiculous that race day quads are the people jumping up and down and making a fuss. It's ridiculous.
I have to say, well done to the guy, because it's Jonathan, isn't it?
And Tyler.
Yeah. Tyler.
Yeah. So top marks to the guy, because the rest of them, and apart from Patrick, of course, who's very verbal, but for the most part, the rest of them in America, the commercial guys, I'm sorry, what are you lot doing? Are you standing there with your trousers around your ankles and bent over, waiting for something?
Yeah, but to be fair, man, you have to understand how it works here. I tell people this: the FAA is punitive. I have this problem myself. I have had FAA managers tell people, if you have anything to do with Egan, we will not do anything with you. End of story.
That's a rule that I like to live by.
I live by
that. Yeah, it's a fair enough rule. That. Yeah.
But that's so people can't do things with me because they're afraid of punitive action from the FAA, and they, you have to accept the frailties of the FAA. I don't have to accept shit. My taxes pay for this, and I'm supposed to go along with it. I'm not going along to get along. I'm just not doing it.
That's absolutely disgusting, though. That
it is disgusting.
A regulator actually has to threaten, commercial ops, because if you deal with him, we will just cut you out. That's or in some way we'll revoke your 107 or whatever they're going to do to them. That is absolutely, that just goes to show, you're not doing anything illegal at all. That's just being petty for the sake of it. The FAA, it sounds like to me like it's less than kindergarten school up there at sometimes, the way they're behaving.
Well, they don't like to be called on anything that they're doing. I mean, I just look at so many of these different things that, common sense is going to prevail and all the rest of it's not. And I had told them years ago when they took my business away, I go, look, you're going to take my business away. I got nothing left to lose. So I got all this free time now to come after you guys. And that's what I'm going to do. And we're going to talk about why this is going on. And what we've seen is pretty much everything that a lot of us have been saying is, most of the domestic hardware, most of the domestic RC, most of the domestic innovation, gone, dead and buried. And so now, we're dealing with, we use Chinese equipment that they basically came to Western countries and got the information on how to use it, whatever else. They're building the equipment. We buy that. And now we're going to look for expertise elsewhere. It's criminal. The other thing with the advocacy groups is the advocacy groups have done the same thing. If you upset the apple cart and talk about how people are doing nothing and paying themselves big salaries, or how they've kiboshed, let's say chances for good regulation because of, personal enrichment or whatever else. I don't know what their motives were. That's criminal. And these people are supposed to be, they have 501c3 status. They're supposed to be going for people's, the betterment of everyone else, even the AMA. The AMA, they've been tripping over their clown shoes, man, since probably the early 2000s. Every time the FAA has clowned them, they just come back for more, It's really a sad thing to see happen. And then the FAA talks, STEM education, we want to get kids into aviation by, making them jump through all these hoops. It's really pathetic.
Yeah, as Sean says in the comments, it happens in the UK, it happens in Australia, it happens in New Zealand, this culture within the regulators. I think if you're going to be a regulator, you have to be a certain kind of person. And often, unfortunately, that's not the kind of nice person that we like. There seems to be a lot of people with what would you call it? Defective empathy, who go out there and say, what's the use of having power if you can't abuse it? And this is endemic throughout regulators around the world, I believe.
Well, and in every subject, we've gotten to a point, I think, in Western government, it's just hey, I'm here, I'm the person, you got to get through me, and we don't care what your solutions are, we're going to do this. And, it doesn't really matter who they're hurting economically. Most of us are really griping about the commercial aspects of this. It is nice as a hobby and for enjoyment, but I always saw this as a way to, help the planet, manage finite resources. We were talking about water during the FERC hearing on part of that thing. There's so many uses, and we all know that, and it's just being stymied for no good reason.
Yeah, it's well. I think I've come away. I will shot this because what time of day is it with you, Bruce? It must be something in the morning.
Yeah, it's just coming up to it's 10 to 6 at the moment.
Oh,
in the morning. Yeah.
But it and Squishy, it's all model aircraft. I thought the guy from the FAA was really actually underprepared. I didn't think he put a good case, and I think if pushed really harder, buttons pushed hard somewhere else. So they've got to go away.
He's the FAA, for goodness sake.
Definitely 800-pound gorilla, and we're the government and this special needs. I didn't even get to the special needs, but we need this. I will say that some of the judges, I was impressed that some of them did sound like they did a little research and read up prior with some of the questions that they were asking. Again, really complicated. This should be the thing to kick the door open on the navigable airspace thing.
Yeah. If that's I'm amazed. If that's what comes out of this, I wasn't expecting that at all. That'd be fantastic.
That conversation should be quoted wide and far and used as an entry point to renegotiate what navigable airspace is. And as Gary said before, it is all the space above 500 feet and within a certain radius of an airport. That's navigable airspace. The rest of it doesn't qualify. So it should be no regulating of models flying in those areas.
Well, then that's one of the squishy deals where the FAA comes in and says, navigable airspace is whatever we deem so it's safe for, air commerce or whatever. I mean, if we're going to go with rules like that, I mean, that's pretty wide open. And like I said, I think if the person, defending the FAA would have given, well, it's down between the airspace and the blades of grass, they would have sounded like a nut, So that does need to be determined, and you would think a group like AMA or AEVSI or one of the other various drone service people, whatever, would come in and do something. But all of those people have something to gain with the dysfunction. Another guy was mentioned that he made comments during the comment period, and that guy was in the RID meetings. And he came out of it and he patented his own technology for RID broadcast.
Yeah, that's what Squish. You gotta realize that the meetings happened, and then meetings that you couldn't get into, and as Patrick said, and I've undermined him, but somebody then patented something on the basis of being sat in a meeting.
And then they have the nerve to try and pigeonhole other folks on the, to win brownie points with the FAA and go, well, somebody came in here and did blah, blah, blah. Oh, really? When one of the forums I asked, I go, well, what was the business model for your patent? Was it just all true? How are you going to, make money on it? There's an effort to get a patent and ram that through and everything else. So most of these people, and even this RID thing, you had, DJI was in there. We already have aeroscope. It's already on the aircraft. Everybody's going to get it. It's the same thing with geofencing. To me, unless I am getting, I want some tangible benefits. Okay, the tangible benefits are, okay, well, you can fly. You don't need Lance because we have this geofencing already built in, and you can't fly here and there and all the rest of the stuff. But we're going to let that go. So it's a tangible benefit for the restriction. Same with RID. If you're going to roll an RID out and go, okay, beyond visual line of sight is here. You can do whatever you want to do. You can fly now because we have the safety thing. Now, I might buy into the RID arguments. Besides that, if there's no benefit, I'm not giving up any freedom.
But the RID doesn't mitigate the risks associated with BV loss anyway. So it's a red herring. I don't think they're going to say, you got RID, you can go BV loss. It's going to be a tiny, tiny component of the overall requirements to do BV loss, but they're using it as leverage to try and get acceptance.
Well, they are, and you are entirely correct, Bruce. I was just using it as an example, but the only thing it's going to be really good for is avoiding a collision with the guy flying the drone in his backyard.
Well, it's not even going to do that because you're visually looking at the drones, so really it's pointless in that respect as well. But
it's broadcasting the location of the pilot, So the arguments, I don't think they're even half baked. I think it's all quarter baked. I think they're grasping at straws. So I've never been in favor of this RID thing. I'm not in favor of the 250 grams and the registration. All of this stuff. There are benefits to the people that are in the room. They go for the low-hanging fruit, and the devil may care. The rest of you people, you're screwed. And I definitely believe that even the registration and the 250 grams, catastrophe even for DJI. I mean, DJI came out with a Mavic Mini, and what are they, 450 grams? And they
249.
249, the little one.
Oh, the little one. Okay, well, they did have products that came out and they were 450 right after the 250 grams, but totally arbitrary. How what effect has that had around the world on the erosion of freedom of people to fly their model aircraft and drones?
I mean, the best thing I think that can come out of it, just going back, is to that navigable airspace. Yeah. If that gets defined, the rest of the world's national aviation authorities will pay attention because sadly, the FAA come up with something and they tend to kind of listen. I say kind of listen.
Mind you, looking at some stuff from the FAA's recently been using the term NAS for national airspace, haven't they? Trying to remove the navigable part of it.
Well, the NAS is the whole system, and the navigable airspace thing. There is no definition.
There is no official definition of navigable airspace. Trees have been used. Now, Jonathan, I know the case, but trees have been used, and New Zealand, where Bruce is, has the shield.
And Australia's latest publication talks about introducing shielded operations as well. So that could be a great way to bolster the case that not all of the national airspace is navigable, because other countries have defined that if you're in a shielded operation, it is no longer navigable airspace from a manned aviation perspective, and therefore that's a precedent.
Somebody needs to get the ear of the judge and say next time, ask the man from the FAA. So we've got remote ID. I've complied with everything that the FAA wants, and I'm flying commercially my drone over a film set completely legally and all lovely jubbly and making a fortune. And a light aircraft flies through the shop and flies through what I'm doing. How does the FAA track that light aircraft? What's the responsibility of that light aircraft pilot, etc.?
Do we know who these judges were? Because,
DC appeals court.
Do we know where they live?
No, but I've got to jump off. I got to.
All right, yeah, no, all right. Now let's make this a good time to go. So, ladies and gentlemen, boys and girls, Geeks Vania, Sean, everyone that's been watching, thanks very much for being with us. I'll trim this one down so it starts right. Bruce, thanks for getting up. Mark, thanks for being there. Patrick, whatever. Yeah, no, thanks as well. Look after yourselves, everyone. Take care. We'll look forward to getting Jonathan on soon to tell us how he thought that went. That will be on a Tuesday night. Cheers for now. Bye-bye.
Cheers. Bye.